This is an appeal in the matter of Wuhi Xinbo Investment Partnership Enterprise Limited Partnership versus GLAS SAS and others.
Just one moment, I just need to adjust my chair, if I can. We'll see. Does it? No, don't worry. I'll be all right. If I get serious backache, I will sue HMCTS.
I'm grateful. Lords, my lady, may it please you, I appear along with Mr. Pask for the fourth defendant and appellant, which is Xinbo. My learned friend, Mr. Bardham, King's Counsel, appears for the claimant and respondent to the appeal.
Yes, I'm sorry to have kept you both waiting slightly.
Oh, no.
I'll have something to say about timing in a minute, but carry on.
I'm grateful. In terms of housekeeping, you should have 4 bundles. 1, the core bundle, 2, the supplemental bundle, 3, the joint authorities bundle, and 4, what was previously an unagreed bundle of documents, but we have no objection to it going in, and that's now an agreed bundle, which is submitted by GLAS. So that's the 4th of the bundles.
Yep.
You should have amended skeletons with references included. As for the appeal itself, clearly it arises out of the decision of Stephen.
Yes, annoyingly, I think I have left mine behind, but I've got the original. It's only for the references, so.
Yep. I'm grateful, yeah. So it arises out of the decision of Stephen Houseman KC on the application of GLAS for conditions. For your note, that application is at the supplemental bundle 89 to 92. As to the order under appeal, that, for your reference, is at the core bundle at 51 to 53. And there are clearly 2 conditions which are under consideration in this appeal today. One is the procurement condition, as I refer to it, and the second was the financial condition for €10 million to be paid into court. As far as the grounds of appeal are concerned, they are in the core bundle at 17 to 18. And clearly our case in the appeal is that the decision was both wrong and that the reasoning was inadequate. By way of update on the case generally, at the moment the stage we're at is disclosure. The trial is listed on the 23rd of February 2025. And
26 presumably.
Oh yes, 2026, yes, that's a mistake. And the unpledged shares, which is of course the subject of this entire action, are secured by a number of freezing orders. I should say that there is some dispute as to disclosure and whether that's been correctly carried out, and I'm sure my friend may have something to say about that. Anyway, that's by way of introduction and context as to where the case stands at the moment. As to the appeal grounds themselves, I'll deal first of all with the procurement condition, which we deal with in paragraph 38 onwards in our skeleton. And by way of context, I should say that the order sought was that Xinbo procure Dynamics compliance with the order of Mr. Justice Knowles, and that was the decision of the 12th of July 2024. And for your note, that order is at the supplemental bundle, page 77. And that order required Dynamic, the second defendant, to transfer what are referred to as the unpledged shares to ETS. ETS, of course, being in liquidation, and that was what the order required. Insofar as Dynamic is concerned, it is common ground between the parties that that is an indirect subsidiary of Xinbo. So as to the procurement condition, the first strand of
Can I
argument...
just ask, when you say it's an indirect subsidiary, it's not wholly owned, is it? It's not an indirect, wholly owned subsidiary.
No, it's 51.9% is owned in another company. I'll give you the details of that in a moment, my lord.
It's in a witness statement.
It's in the witness statement. It's in the witness statement, and it's in the defence at, I think it's paragraph 4. Yes, core bundle, page 92. Which paragraph number is that? It's paragraph 6, subsection 5.
So core 92.
Yes, core 92. So Dynamic owns 51.9% in joining Ruyi Garment Development Company Limited. And the other shares are held by Winjan Weishan Industrial Fund, and JRGD in turn owns 100% in a company called Jining Ruyi High Performance, which in turn owns 100% stake in Dynamic. So it's indirect and not 100%. So you're right, Rod. That's the position. So the first strand of argument regarding the procurement condition, and of course many of these grounds are common to both conditions, is that there was simply a failure to give reasons or adequate reasons. In terms of the authorities, I think these are probably quite well known.
Yes, I mean, I think you can take it that, I'm sure will come as no surprise to Mr. Barden, that we do not find the form of the reasons very satisfactory. There may be some key points you want to make, but I don't think you need to spend a lot of time on that. Suppose we were to decide, however, that they did not reach the standard required by law to be proper reasons, we are still going to have, both really for the purpose of deciding that in the first place, but also as a consequence of any such decision, to decide what order the judge should have made. That, I suspect, is where the focus of the submissions are going to have to be. That may take a bit longer than the half day that was allocated. I think that was the spirit, though not the letter, of my lord's estimate. So we're prepared to sit on into the afternoon if it proves necessary. You may both be very economical, but you're looking puzzled.
No, I'm not puzzled at all.
No.
My lord. No, I'm grateful for that indication. My lord, I take it from that you don't want me to go through the authorities that we've cited in respect of proper decisions. We've relied on Symmetra.
I wouldn't have thought so, and I forget which the ones are you might refer to. I remember
Yes.
they're all very familiar. Let's just take your skeleton out. I'm using, I'm afraid, the original version, but the paragraph is a bit the same. Which was the paragraphs where you set out points about reasons?
So we refer to Symmetra in paragraph 29.
Yes. Then obviously English and Emery, Reinbold, I should say.
Yes, we rely on paragraph 39 of Lord Justice Mayles, which
And a bit more about Symmetra in 31.
yes, which I'm sure is quite familiar.
Yes.
And we also rely on, yes, in paragraph 31, we set out paragraph 46 of the case, simply dealing with the way in which a judge ought to deal with the reasoning for the case. So I won't go into that. Both parties, I should say, rely on English and Emery Reinbold, and this is dealt with at paragraph 30 of our skeleton.
Yes.
And I think this is all very familiar stuff for the court.
We may, but I have to look up particular things said in those authorities in connection with particular points. But in terms of the broad principles, I think you can take them as well understood.
I'm grateful. Lord, can we just go to the judgment now, which is under appeal, which is at page 55 of the court bundle. And in paragraph 1, you'll see that the judge places reliance on a number of different matters there. The judgments of Mr. Justice Bright and Mr. Justice Knowles, the circumstances set out in Malone and Friends skeleton at paragraph 4 and 5. For your note, they're the supplemental bundle at 142 to 146, and just to give you a précis of those paragraphs, paragraph 4 relates to the facts surrounding the bonds and the disposal of the shares to Dynamic, and Mr. Justice Bright's judgment, and paragraph 5 is a potted history of the proceedings to date.
Yes, I speaking for myself. I've looked at that, and
Okay.
they are a pretty full summary.
Yes.
Your point is more clear enough what he takes about from the claimant's case. It's less clear how he deals with your answers.
Yes, exactly.
Considering less full.
Exactly that. And obviously in paragraph 2 he refers to his scepticism about separate corporate personality. Paragraph 3 he deals with very briefly with the absence of pleaded relief at that time.
Yep.
He says even though there is no monetary claim, even though it is the case that D4 has not behaved procedurally for as long or in the same qualitative way as D2 has, I'm nevertheless persuaded it's in the interest of justice that D4 post security and has conditions imposed.
Yes, well, go on, yep.
I'm sorry, my lord. Didn't mean to interrupt you.
No, I was just going to remind you we have read the judgment.
Oh.
It didn't take very long.
No, indeed.
But you must obviously make the key points about it, but you don't just have to tell us what's in it. We can see
No.
that.
So my next argument regarding that is that clearly we say the judge didn't properly deal with the separate corporate personality of Xinbo.
I just didn't formally address yourself. So I didn't hear what you said.
Didn't properly deal
Properly, sorry.
didn't properly deal with the argument regarding the separate legal personality of Xinbo. And in respect of that, we've cited in our skeleton pressed, which is obviously a case to which.
Yes, it would be helpful actually though, just to have in one place what you say are the points with which he did not properly deal. So one is the separate legal personality point. You can come back and say what you about Preston in a minute. That's one. What else did he not properly deal with?
We also say that he didn't deal with the issue of whether we can comply with the procurement condition.
Yeah.
And we also say that he didn't identify a proper purpose for the procurement condition.
So I just didn't. I'm reading deaf. You'll have to.
He didn't identify a proper purpose.
Proper purpose
for the procurement condition. And fifthly, we also say that there's
Fifthly, I'm sorry. I thought
that's 3. We're
3.
now on 4.
Oh, is that? I think yes. I think I've numbered them slightly different in my submissions. But the next point would be that there's an argument about lex specialis, which is regarding our argument about the particular rules that would apply if one were to seek, for example, a mandatory injunction against the party. And I think you've seen our arguments on that. I'll come back.
Okay, you raised that in the context of the financial order. Are you also raising that in the context of the procurement?
Yes, we do raise it in the context of the procurement order. Now, our case on that, which I'll come back to.
Well, don't worry. Yeah.
You can explain that.
Yes.
I wasn't asking you to develop the submission. I thought it'd be helpful to have in one place what you say are the reasoning failings in the judge's judgment. So reasoning failing 1 is doesn't deal with the fact you're a separate legal person from Dynamic.
Yes.
Secondly, it doesn't deal with whether you can comply with the condition. Doesn't deal with doesn't identify a proper purpose for the condition. And fourth, the I don't know why you call it a lex specialis point. It's a rather odd way of putting it, it seems to me, but it's basically getting round the conditions that you would have to satisfy if you ask for a mandatory injunction.
Exactly.
Okay. Anything else? Are those the reasoning failures which you are relying on?
Those are. Those are the reasons. Yes, I think the one other matter we would rely on would be proportionality in relation to the actual default of Xinbo.
Doesn't deal with proportionality. Okay. I appreciate these are both, as is nearly always the case, these are both substantive points and reasoning points.
Yes.
Yeah. Okay.
Shade into each other.
Okay. Right. Now you're presumably going to develop those, but well, you've perfectly sensibly divided your submission up into your first strand, inadequacy of reasons, and I imagine your second strand is going to be the substantive points.
Yes.
There isn't much more to be said about the inadequacy of reasons, is there? We can see what he says and doesn't say about them. Mr. Barden will try and persuade us they're enough if you look back at the cross references and so forth. You may want to say something about that now, but that's a fairly straightforward part of the case, isn't it?
I think it is, yes. I don't think there's much else I have to expressly say about reasons as such. I was going to go on and talk about the failure to deal with the separate legal personality.
Well, as a matter of substance rather than as a matter of inadequacy of reasons.
Well, yes, I mean, I think it comes into both. But
well, I know it does. I'm sorry to be too fussy about this, but just for the purpose of my notes, I'd written down first strand, the inadequacy of the reasons.
Yes.
It would do it any way you like, but I just thought the way you were going to do it was to separate out your substantive submissions from your inadequacy of reasons submissions.
Yes, well, I think that is largely how we deal with it.
Yes.
And as you say, my lord, there's not really much else to be said about the reasoning. It's fairly short.
To some extent, you have to go into the substance in order to explain why the way in which the judge dealt with it is inadequate.
Yes.
In other words, if there's no substance in the point, or once we understand the substance of the point, then we can assess whether the judge's reasons were adequate or not.
Yes.
Or at least get a better feel for it. So, I mean, certainly speaking for myself, it's helpful to see what you say the substantive points were that you say he didn't deal with sufficiently.
Well, can we then proceed to that, which I think, as I understand what you were intending to do, is your second strand, which is to go through those 5 points, and indeed any others where you say the reasons were adequate but wrong, though I'm not sure there are any. As my lord says, that will in practice overlap with what we'll have to consider in deciding whether the reasons are adequate in the first place.
Yes, no, absolutely.
Okay.
Grateful. So, yes, I mean, dealing firstly with the separate legal personality of Xinbo, our key point in this is that, obviously, as we've already made the point, Xinbo is an indirect, not wholly owning parent of Dynamic. And as matters stood and as they stand now, the only order in respect of the transfer of the shares was the Knowles order, which was made against Dynamic only. And our rather simple point on that is that we say that it's not enough to say that Xinbo was an indirect, albeit not 100% owner of Dynamic, or to refer to its nomineeship or Dynamic's nomineeship in respect of the unpledged shares.
So what's the other side of a nominee principle?
Yes,
Yes,
I think that's right.
Those are two very different points.
They are.
I mean, the corporate structure,
Yes.
and it's why I asked you the question about earlier on that it's not a wholly owned subsidiary. As I understand it, there are external shareholders who can't simply be ignored in the way a corporate structure functions. in the way that they could be ignored if, or at least in many ways, if it was a wholly owned subsidiary running all the way through. And I think you make the point that there are external shareholders.
Yes.
Now that corporate structure, i.e. the ability of the judge or somebody in effect simply to collapse the corporate structure and say, oh, it's all very technical, this is nonsense, is something to which I fully understand as a corporate lawyer. You say, wait a minute, you just can't do that.
Yes.
Especially where there are external shareholders involved.
Yes.
The nomineeship is a completely different thing.
Yes.
The nomineeship has nothing to do with corporate structures. The nomineeship is that one entity is holding legal title for shares on trust for another. And that's some form of equitable relationship or contractual relationship, which has nothing to do with the corporate structure. So I think it's worth, isn't it, trying to separate out the two. And my understanding is one of your objections is the judge collapsed the corporate structure in a way which was inappropriate and simply didn't deal with the nomineeship question at all. Or it may be said against you that the nominee point is in fact the answer to this case, but the judge didn't deal with it.
Yes, I mean, I think that'd be a fair representation of our submission of that. I mean, we do say that he collapsed the structure in an impermissible way and assumed that Xinbo ought to take on the responsibility for procuring Dynamic to transfer the shares in a circumstance where the structure of ownership simply doesn't allow for that assumption to be made.
But that's not dealing with my lord's point. My lord's point is you may be right about that, but what about the nomineeship, which is not nothing to do with corporate structure?
Well, he doesn't. He just simply doesn't deal with the.
I see. So that's the judge fails to deal. Okay, but suppose he had dealt with it. What would the, whether or not he's dealt with it? What is the answer? That if you are the principal, it is in your power to tell the nominee what to do with the trust asset.
Well, I think in principle that is correct, what I would say, but what we don't know is whether Dynamic will actually comply with an instruction. And the difficulty is, of course,
Again, you don't know if they can actually comply or
we don't know
would
if it
actually.
would. We don't know if it would comply with an instruction.
That one thing the judge did say was this is all a bit unreal. As I understand it, the pleaded defence of both Dynamic and Xinbo is that Dynamic was acting as the nominee of Xinbo.
Yes.
Effectively, therefore, it was Xinbo that directed, if you like, the shares to be transferred to Dynamic, presumably, or selected Dynamic. What's your answer to? And then you say you're just saying we don't know if Dynamic could comply. The judge was saying this is all unreal. What's your answer to that?
Well, the judge certainly was sceptical about the separation between the parties, and did say that he found it unreal to an extent. Our answer to that is that Xinbo remains a separate corporate entity, and insofar as there is a nomineeship in existence, we accept that we can give an instruction onto that relationship, but we don't know whether it will be complied with.
Well, you say insofar as there is a nomineeship, that's the pleaded case.
So I don't mean to cast. Well, lady, I don't mean to cast doubt on that. So forgive me for.
Case.
It is, and I don't mean to cast doubt on that. I'm not suggesting that there's any doubt about the existence of that relationship. That's my loose language, for which I apologise. What I can't say though is what the result of an instruction from Xinbo to Dynamic would be.
But in circumstances where both parties say, in one case I am the principal, the other says I am the nominee, the default position will be that the nominee will do what the principal says, unless some good reason is shown why they would not. And haven't seen anything in your submissions below that gave any reason to doubt that Dynamic would not obey an instruction from Xinbo. Surely the burden was on Xinbo to show some reason why that might not be the case, or what might be the case, depending which way you're putting it.
Well, I can't point to anything, my lord, which would suggest that Dynamic. I mean, I don't have any evidence to show this tribunal that there is anything to suggest that Dynamic won't comply with an instruction. Our starting point, however, is that Xinbo ought not to be subject to an obligation which is tantamount to enforcement of an order against Dynamic, which is what the procurement condition does. So we say that the procurement condition is just being used as a means of enforcement through Xinbo against Dynamic, where GLAS is perfectly entitled to go off and enforce its judgment by conventional means. So it's, yes, there is a nomineeship. Yes, we can give an instruction. No, I don't have anything to show the court which would suggest that Dynamic will not comply with it. But we object in principle to the imposition of that obligation on Xinbo as a separate corporate entity in circumstances where that condition is plainly being used as a means of enforcement.
But if so just cycling back a touch, you see, I look at paragraph 2 of the judgment, which really seems to be dealing in exclusively, as far as I can understand it, with the corporate structures.
Yes.
And the questions of separate corporeality and control. And I've said what I've said about that. It doesn't deal with nomineeship, at least on its face. The judge just didn't grapple with the point. But if you had an order made against a bare legal owner, a nominee, to do something, I can understand that the nominee would say, well, I shouldn't be ordered to do this because actually I'm just a bare legal trustee. I hold bare legal title for somebody who is beneficially entitled, and you should really be engaging with that person because it's that person's interests who are really being affected by this order. But the real question then is, when you are that beneficial owner, whether the order is properly made against you. Because, as my lady said, if both nominee and beneficial owner are engaged in the proceedings, the court really just then ought to deal with the substance of it, not get concerned about the fact that you've got a bare legal owner on the one part and a beneficial owner on the other. So I mean, simply to say these are different companies doesn't answer the substantive question of, is it right to make this order against the beneficial owner? Well, sorry, that was a very long and rambling question. I was trying to explain the point very badly.
I mean, I see where the Lordship is going with that point, and I think the answer to it is, of course, that what ought to have happened at the beginning of these proceedings is that Xinbo ought to have been joined as a party, and that the orders that were obtained against Dynamic, there ought to have been an order obtained against Xinbo at the same time to bind both the beneficiary as well as the nominee. I mean,
the question really becomes as to whether it's appropriate to make this order as a condition in effect of your client, the beneficial owner, having the ability to defend itself in these proceedings.
Well, we say it's not appropriate to make an order against us.
But that's one of your other points.
It's one of our other.
But if this had come up as a summary judgment application, as it could,
yes,
the real question then would be, having regard to all the circumstances, including the merits of the defence, is it appropriate that you, being effectively the beneficial owner of the shares, should have to pay money into court, or no, that's not the right, or procure the transfer, I suppose, rather than
Well, we would say,
as a condition of leave to defend.
well, my lord, we would, if that were the application which were made, we would say, one, that we don't agree that the defence is necessarily weak, and clearly there's been no application for summary judgment made. Two, insofar as the default was concerned, we don't consider it proportionate or reasonable to order us to transfer, to be compelled to transfer the share, and it doesn't go to any procedural purpose of regulating our conduct as a
Okay,
defence.
well, that may be one of your points. Okay, I'll park
There's a-
that, because that's one of the points you're going to come to about doesn't identify a proper purpose.
But there's a further point, of course, which is that Xinbo says that it's entitled to the shares, and of course that's going to be the subject of the
Yes.
trial of these issues, and having the shares transferred over rather prejudges some of the
Yes.
substantive issues that are going to be the subject of the trial. So Xinbo would say that it
Yeah,
somewhat jumps the gun.
See, that's what I thought your argument was on the substance, that the order for transfer of the shares doesn't indicate that the shares are to be held on any particular terms pending the outcome of the dispute as to whether Xinbo is in fact entitled. So in truth, it almost renders the trial moot, doesn't it?
Yes.
Sorry, can I just understand that a bit better? The order to transfer the shares made by Mr. Justice Knowles followed his summary judgment that the transfer was at an undervalue and should be reversed. So is what my lord said entirely accurate? I appreciate that was as regards dynamic. So
Yes.
it's a little bit complicated.
That's the issue.
Yeah,
It's
and it
about
ends
whether-
up being a bit circular.
Well, it's a question. I understood your point was an order's been obtained for on the basis that the transaction was a transaction undervalued, but against the nominee in circumstances where the beneficial owner was not a party and is not on the face of it bound by that determination, and wants the ability to argue in its own right against that proposition at trial. And this is the problem, as I understand it, with the judgment having been simply obtained against the bare legal owner in circumstances where the beneficial owner wasn't joined. Now, there may be all sorts of arguments about why that was and the like, but my understanding was that your argument was that you're wrong in principle as well to order the unconditional transfer of those shares against the beneficial owner or party claiming it was the beneficial owner of the shares before the issue of the validity of the original transaction had been determined as against that party. Because
That is
if you succeed, if you succeed, I mean, there's no indication as to what's to happen as to whether the shares are going to come back to you.
no, I mean, they just go into the hands of ETS, which is in liquidation, and we've got no control over the shares. And that, as you say, in the trial could be
That's the
completely.
substance which we'll come on to. I mean,
Yeah.
simply saying, well, the judge's corporate analysis was wrong and he didn't deal with nomineeship, sort of isn't a complete answer given the nomineeship to this case.
No.
We have to dig a little deeper, as I understand it, to understand the substance of the arguments that are going to be made.
Just thinking aloud here, and I hope I'm not starting a hair, is we go down that route, the real point may well be whether it is, notwithstanding the the formal difference of parties, there is a form of issue estoppel or abuse of process that prevents you challenging the decision of Robin Knowles, Mr. Justice Robin Knowles, in the action, in the dynamic, in his judgment against dynamic, given that you were certainly fully apprised of what was going on and were the beneficial owner of the shares in question. It may be that that's not the way it's put, or not the way it could be put, but I'm just raising it as what might be actually the correct analysis behind whether or not it's right to effectively treat you as bound by a decision in which you were not a part, to which you were not a party. That's the legal area we're in, isn't it?
Yes, and a lot of touches.
There are such cases.
You say
Sometimes it's in terms of whether you're a privy, but
Yeah.
it doesn't have to be.
It isn't for issue estoppel, it would be privy.
Yeah.
but you say that none of
For abuse, it would not be. Yeah.
you say none of this was explained by the judge in his judgment, and I mean.
No, and it's an interesting point because it goes to the ability of Xinbo to participate and defend the proceedings at all, and whether it ought to be able to challenge transactions after the judgment against Dynamic. But as you say, Lord, it's not something that was dealt with by the judge. It's not the way the case was put. And of course, one of the points we make, of course, is that when Xinbo was joined to the proceedings and was permitted to file a defence, there was no objection in principle raised at that stage by GLAS to Xinbo's participation. And of course, when Xinbo was permitted to file a defence, it was permitted to do it unconditionally. And at that time, there were prevailing breaches by Dynamic of the orders.
So, can you remind me of the chronology? Did Xinbo become a party post the Knowles judgment?
Yes, we did.
And nobody said, well, there was no point in that because you were bound by the determination in the Knowles judgment, so there was no point in becoming a party. I suppose the point is Xinbo was, amongst other things, going to face not just the claim in relation to the return of the shares, but also a claim for the damages for the shortfall.
Yes, and there was no submission made at that stage that it was not permissible for Xinbo to pursue its own interest and seek to establish its interest in the shares. And nor was it said at the time, importantly, for the point of view of conditions, that Xinbo's participation ought to be subject to condition because of the pre-existing breaches by Dynamic, both in respect of the transfer of the shares and in respect of the payment of the condition ordered by Mr. Justice Bright.
I mean, the point I've just made is it picks up paragraph 3 of the judge's judgment. I mean, paragraph 2 I've already made my observations on. Paragraph 3, the judge appears to proceed upon the basis that there's no monetary claim made against your client. So that's not the basis of any of the judge's decision, i.e. that you were faced, as it were, that the claim against your client was a monetary claim. Anyway.
No, I mean that was one of the points, of course, that we relied on quite strongly at the hearing, which was that at the time we were in the slightly strange position of having been joined and given permission to file a defence unconditionally. We were then late with that defence, but there was at that time no pleaded case in damages against Xinbo, in respect of which the judge could have taken into account, for example, to make a financial condition.
So the only basis for you to be joined was to argue the very point of whether the original transaction was improper or transaction undervalue or otherwise. So it would be a little bit odd if you were then told actually you couldn't argue that because it was all issue estoppel, etc., etc.
Yes, I mean, exactly.
I think that's I think that's what I understand your sort of position to be. Right. Okay, good.
So we also say that what the judge didn't consider, and it's shades of something we've already covered to some extent, is whether we could comply with the order, and we've gone into the subject of nomineeship and also the structural point, and we deal with this in a number of different ways at paragraph 48 of our skeleton.
Okay.
Well, we set out some of the examples of the practical matters, which I'm sorry,
No, go on.
of the practical issues that we say the judge should have been cognizant of. One is the freezing order, which presently exists in Singapore, granted in the 19th of November 2021, which is of course an order which was made against ETS and Dynamic, and of course the proceedings underlying that are between GLAS, ETS and Dynamic. And for your note, that is at the supplemental bundle, page 14. Don't think we need to go to it. But the short point about that, of course, is that clearly we can't deal with that. Xinbo can't deal with that order itself. It's not in its gift. That's a matter for Xinbo and Dynamic to deal with. And we
Sorry, for who in Dynamic?
sorry, that's
But
a
ETS
matter
and Dynamic
for GLAS and Dynamic to deal with. Forgive me. So we're not party to that order. We can't do anything. We can't try to vary it in any way. That's got to be done between the parties to the freezing order in Singapore.
Yes, but surely the thinking behind it is the same as the thinking behind the transfer generally, that you could apply to the Singapore court and if the application was unopposed, and it's hard to see who it would be opposed by. I think you said the other order in Singapore is the other party, in fact, is ETS, but we know what the position of the trustee of ETS is. There wouldn't be any difficulty. You tell Dynamic to do it, and Dynamic will do it.
Well, do you mean, my lord, to tell Dynamic to make the application, or for us to make the application?
Well, I
Well-
assumed that was the thinking.
Well, I mean, again, it comes back to what we would say is an assumption that cannot be made, that we can simply tell Dynamic what to do. And we say that the structure, the ownership structure of Dynamic by Xinbo is simply not one where we can ignore other shareholders, for example.
But you can order it as nominee. That's why I tried to draw that distinction earlier.
Yes.
I think that's complete at the moment. To hearing you, I mean, it seems to me that the corporate structure point is a bit of a red herring, if in fact the common position is that it's a nominee relationship. I mean,
It's
if you had Lord Debenture holding as nominee, for the beneficial owner, beneficial owner could simply instruct Lord Debenture. I choose them just because they provide trustee services. Just to be clear, the court would simply say, "Well, just tell Lord Debenture to do it." What's the problem? You both agree it's a nominee relationship. What's the problem? And they're not corporately connected.
Yes, and I suppose it just comes back to my point, which is, well, yes, we could give that instruction. We don't know what the result of that instruction will be. And of course, the other point, of course, is not about the ability to do it, which is the point of principle about whether you ought to have that condition applied to Xinbo as a party which seeks to assert its own interest in the shares, and which we say should be the subject of the trial in any event, rather than prejudged by a condition which will.
All right, but then that
It's a slightly different point.
ceases to be this point.
It does cease to this point, but if that's the answer to this point, that's where I have to go, I think,
Yeah,
in terms of my argument. So I hear what the court says on that.
Perhaps I can just mention at this point, but you maybe we're going to deal with it later. Mr. Barden says about really all these points that you have the protection of the judge's order, saying that if there's difficulty about practicability, I think, you can tell me if I'm wrong, this applies both to the procurement order and to the payment order. There's difficulty about compliance. You have liberty to apply within whatever the timetable was that he set. That was quite a realistic thing for him to do, wasn't it?
Well, we say that that actually is just a demonstration of why the order ought not to be imposed in the first place. If it's one where there's such doubt as to whether Xinbo can actually comply, the question I have is, well, the point I make is that it ought not to be imposed on Xinbo in the first place. And the so-called safety valve that Appellant friend refers to, we say is nothing of the sort, and it simply displays the uncertainty of imposing this type of order on Xinbo to procure the transfer by Dynamic in circumstances where we say that the result of that safety valve is going to be further dispute, because of course the question arises, what does Xinbo have to do in order to comply with it? So if it gives an instruction to Dynamic and for whatever reason it's not complied with, or it doesn't get a response, what does Xinbo then have to do? Does it then have to instruct BVI lawyers to start taking formal steps, such as they can be taken to take control of the board of Dynamic? I mean, it's a very, we say that it really opens a bit of a Pandora's box in terms of what Xinbo has to do, and it's inevitably going to lead to some kind of satellite litigation and disputes, because no matter what we say, we expect it probably will not be enough.
Yes, I see. Sorry, that was a response to a question that I made. You were going through your practicability difficulties. The first was the freezing order. What were the others?
The first was the freezing order. The second is the bank mandate at JP Morgan. And I imagine the court might have some similar points to make on that. But of course, we're not party, we're not a signatory. There's some confusion actually as to who is the signatory. Our understanding was that Ms. Q, the third defendant, was the signatory on the mandate, but she has, as I understand it, has said that she's no longer the relevant individual.
Well, this is since the hearing in front of the judge. Is this a subject of evidence and I've just missed it?
I think it was before. I think it was before the hearing in front of.
Was it? I see. Well,
So-
I hadn't picked that up, but
Yes. So well. So we would need to find a way of compelling Dynamic or JP Morgan to alter the mandate or to accept instructions, and we simply don't know how that process would unfold and how long it would take. It would play the point about nomineeship, but assuming that we give an instruction that nothing happens, we're looking at getting into matters of Singapore banking law and BVI company law in order to sort out the issue with the mandate.
If this does beg the question that if the nominee arrangement exists, as you and Dynamic say, these points you're making now should be of economic fundamental concern to Xinbo in any event. Because you've got Dynamic, which you say is nominee, holding some still valuable shares on your case as nominee, and you say we really don't know if we can access them, and implicitly we haven't tried.
Well, clearly the leadership is right that our assumption would be that if we give an order, then the nominee will comply with that order, but we just don't know whether it will comply with the order. It matters as technical as this regarding the bank mandate. If we don't get a response, for example, I mean, it may be that they don't refuse to comply with an order. We may simply not get a response. We don't know. But if that's the case,
But my lady's point, sorry, you're not really dealing with this, but I say
Oh,
with
sorry.
my lady's point is, if your client is right, Xinbo is right, they're your shares. It's surely you'd like to know whether your nominee will do what you ask it to do. Now,
yes,
the
yes,
real issue is you've been ordered to or say it has been ordered to do one thing by a court in proceedings to which at that stage you weren't a party, you now want to be a party to argue the point that was decided against your nominee. And the question is whether you should be required to do something as a condition of having that ability.
Yes.
But my lady's point to you is, either way, why don't you want to know what your nominee is going to do with what you say are your shares?
Well, apologies, lady, if I didn't quite pick up on that point correctly. Well, I think it's a fair point. I think we would like to know, but as matters stand, the shares are perfectly adequately secured
But how
by
do
way
you
of
know?
freezing order, and nobody can move them. So,
But that's not a freeze. That can't be the answer because you've just told us the freezing order is not something to which Xinbo is a party.
no, but
Dynamic could agree to a variation in that freezing order tomorrow. It doesn't. Okay, let's move on. But I'm not sure that answers.
well, as matters, well, I see your point, lady, that our interest could be at risk if Dynamic agreed to a variation of the order. But as matters stand, clearly we can't take steps to. We couldn't ask Dynamic to transfer the shares back to us, given the nature of the freezing order regime that already exists. So insofar as, yes, I can imagine that Xinbo probably would like some comfort to know as to what Dynamic will do with its shares. But I'm struggling to see what practically we could do at the moment in order to get some comfort in that department, because obviously transferring them to ETS is wholly unsatisfactory for us, because it goes into the hands of the liquidator of ETS with no condition attached as to what happens. But we can't have them transferred back to us either because of the nature of the freezing order regime which is in place. So I mean, I do see your point, Liddy, but I just don't know what practical steps Xinbo should actually take to get comfort in that respect.
Very well. So, freezing order, bank mandate. What else?
Well, we've already been through the indirect at not 100% ownership of Dynamic.
Well, what do you mean by that? What practical difficulties does that arise? Are you saying that the appropriate resolution, that there'd have to be some resolution of by the board of well, I'm not quite sure what you're saying.
Well,
on the question of practical difficulties.
and on the question of practical difficulties, if we give an instruction which isn't complied with or is ignored, then Xinbo would then have to consider what action it could take in the BVI.
That's making an assumption which there's no reason to make.
Well, we can't assume either way.
I take your point. I sort of take your point. There's some difficulties about the freezing order of the bank mandate, because those are things that actually would have to be done.
Yes.
But this third point is assuming a disregard of your instructions, which, on the evidence, the clear default assumption is that a nominee does what they're told by their principal.
Well, I can't put it any higher, my lord, than this is in the event that our instruction is not complied with or is ignored in some way. We would have to take steps to regulate the position of the BVI. But I take my lord's point.
Okay.
And we say the judge himself was concerned, it seems, from the hearing as to the practicality of making this order. And we can see from the transcript, and I'm not sure if you've had a chance to go through that in detail.
Well, sorry, just a tiny point on that. We've got it in 4 pages to the page, which for my old eyes is quite difficult to read. My clerk made a request to have a full have a full page version. I don't know whether that got through to anybody.
I'm not sure that it
Tried to speak to your Chambers clerk, but was told she couldn't.
Oh,
And it doesn't
Surprised-
matter. It doesn't matter.
surprised
But the
with
bottom
that.
line is, have you got a full page version? I can manage if not, but it's just so much easier.
we can get one apparently. Yes, well, Lord,
Well, let's work with what we've got at the moment. Yep.
So, if we go to the supplemental bundle at page 179,
Yeah.
and it's page 15 of those rather small pages, and it's lines 5 to 24.
Can I just read the whole bit?
Yes.
Sorry, where were you asked us to read? 15 to 24?
It's lines 5 to 24.
5 to 24, yes, sorry.
At the top right hand side is page 15.
Yes.
I'm grateful.
Yes, okay, thank you.
And then there's just on the same page, just down towards page 16 of the transcript, just lines 4 to 5, where you see a further comment by the judge. It's just a question of what it is fair to require them to do.
Oh, I see. Well, that's just a continuation of
It's just a
the same
continuation.
passage. Yes, I'd read that.
And then if we could go to page 176.
Hang on.
Page,
Sorry, just one moment.
176.
yes, page 176
Of the bundle.
of the bundle, yes.
That's going backwards.
Yes, apologies, it is going backwards. I should have taken you to that first.
176, yes.
Yes, so it's page 4 and it's lines 13 to 19.
My understanding of the transcript is that this concern by the judge led to the liberty to apply provision being included.
Yes, I think that's a fair point, lady. Yes, but our point is that he was plainly alive to some of the difficulties of imposing this procurement condition on Xinbo, and
He doesn't really say what. Well, I suppose he's referring to the ones you've referred to. Yeah. Yeah.
And he ought to have been cautious about applying a condition such as this, given his own concerns and given the points that we make. And of course, caution is one of the watchwords of applying a condition, and we cite in our skeleton Gamma Aviation. I'm not going to take you to that because it's a case that is well known to this tribunal.
But if all your objection is that the judge should have been cautious about or arrived to these problems, etc., etc., I mean, in essence, why wouldn't you have to go a lot further than that and say that there's something actually irrational or wrong about the mechanism that the judge used? I mean, do you say that all other things being equal, the decision to make the condition but with a liberty to apply was a decision the judge couldn't have got, shouldn't have got?
Yes, we do go that far. We say it's a condition he ought not to have imposed, and it was wrong.
But that, see, I'm not sure which of your points you're on. It's your third point. Was there a proper purpose for imposing the procurement condition? is the substantive question. If you're right that there was no proper purpose, then you're right and the rest falls away. If you're wrong, why was the judge wrong to effectively say, well, I'll impose it subject to liberty to apply?
Well, we say it was wrong to do that because of what we say are firstly because of the separate personality of Xinbo. And it's wrong to impose the obligation on Xinbo to effectively enforce a judgment against Dynamic, a separate party. And as we'll come on to in a moment, we also say that it's in effect obtaining a mandatory injunction against Xinbo.
Yeah, well, that's a separate point.
It
It's
is a
helpful for us to divide your points up.
But we say it ought not to have been made, not just because it was not for a proper purpose, but we also say that given the practical matters that we identify and also the separate personality, the principle is an order that ought not to be imposed.
Okay. Let's then move on to proper purpose or judge's failure. Well, that there was no proper purpose for this, or the purpose which the judge apparently had was not a proper one. Is that right?
Yes. So on proper purpose, paragraph 33, we deal with some of the authorities on this, which I'm sure you're all very familiar with. Which is
Well, let's just remind ourselves what the essence of those is. Yeah, this is effectively Huscroft.
Yeah, so we rely on not just this Murbic in Huscroft.
That's about security for costs.
Yes, there's some general stuff about identifying the purpose of imposing a condition and having in mind that it represented a proportionate and effective means of achieving that purpose.
Yes.
Paragraph 34, we also deal with Al-Subahi and Al-Sanea. And we set out the judgment in paragraph 11 of Lord Justice Mayles. The purpose must be explained and the condition must be proportionate and effective means, and it's not an alternative means of executing a judgment.
Well, Mr. Barden may not accept this characterization of what his case is, but as I read it, his case is that this is effectively to require an earnest from Xinbo of its intention to pursue this, as he would say, you deny, apparently weak defence, already been held by other judges to be weak. So effectively, it's a purpose analogous to a summary judgment application. Okay, the judge doesn't spell that out.
Yes.
But let us suppose that that was in fact the purpose or a possible purpose. Why wouldn't it be legitimate?
Well, can I just unpack that point slightly, my lord, in this sense? We say that if that were a reason for imposing a condition on Xinbo, that the nature of its defence was such that it ought to put in earnest money in order to defend, then that ought to have been raised at the time when Xinbo was given permission to file a defence. These are all reasons.
You mean when it was joined?
Or when it was joined.
Because
Yes.
I think that's what you're referring to, because actually it needed relief from sanctions to file.
Well, we were given permission to file a defence and we didn't file on time.
Yes.
But then you needed.
So we were joined and then given permission to file a defence, but we didn't comply with that. But nonetheless, I say that all of these reasons, if you like, the arguments about subverting the orders and the arguments about the defence, we say are all reasons which existed at the time that Xinbo was given.
Well, all right, but
defence.
but the concept of a proper purpose is substantive.
Yes.
It doesn't really matter at what procedural stage it's raised. You may have your separate point about lex specialis, which you're coming to next, but on just whether that's an illegitimate purpose for imposing a condition, you don't say it doesn't become illegitimate simply because it's a similar condition or a similar argument could have been deployed at an earlier stage.
No, I'm undoubtedly
I'm misunderstanding your point.
undoubtedly that's correct, Lord. I think my point is that clearly when Xinbo was joined to the proceedings and was given permission to file a defence, the points weren't raised, and we infer from that that there was no objection in principle raised by GLAS to Xinbo participating in the proceedings despite its misgivings about our defence. So, I mean, clearly it is a legitimate thing for the court to consider. I don't think the judge actually goes into much detail about what he thinks of our defence in the judgment.
He does cross-refer to Mr. Justice Bright's decision, which does include quite a lot of comments, obviously about dynamics defence.
Well, he does, milady, but the difficulty is this, that he says in paragraph 1 that he's read the judgment of Mr. Justice Bright and he's read Mr. Justice Knowles' judgment as well, and that he's taken on board that fact pattern and behavioural profile. It's quite difficult reading those words to actually glean that he's really thinking about our defence. I mean, it seems that the focus of the judge is much more on the history of default in the case, if I can put it that way, by dynamic. And that seems to be the real gravamen of his judgment.
Well, for all the reasons we've already looked at, sometimes quite hard to see clearly, or at any rate explicitly, what his reasoning is. Speaking for myself, I understood his references to the judgments of Mr. Justice Bright and the order of Mr. Justice Robin Knowles as being incorporating their views about the merits of what's substantively the same defence.
Yes.
But even if you're right that he was that isn't quite what he had in mind, or it's not clear that it's what he had in mind. If he had it in mind, or if we were having to make the decision, isn't it legitimate to do so?
Well, Lord, it certainly is a legitimate consideration for the court to take into account. I certainly couldn't disagree with that is one of the matters which the court can have regard to. But I would say that in this case, considering Xinbo, and Xinbo's position, we say that the position that pertained before Mr. Justice Bright, for example, when he made an order for conditions, we say that Xinbo's position is entirely different to that. And although it will be said against me that our defence suffers from the same frailties that dynamics does, we say that the context in which Mr. Justice Bright made his order for conditions was entirely different, and that even if the judge had taken into account what are said to be the weaknesses of the defence, which I don't accept, we would say that even putting that to one side, even if that were the case, this is a very different set of circumstances to that which was before Mr. Justice Bright. Mr. Justice Bright was looking at this case where Xinbo had basically done nothing for, Dynamic had done nothing for 2.5 years. It had ignored freezing orders, and the judgment goes into great detail about the procedural defaults of Dynamic. And although Mr. Justice Bright also considers the defence, that is a judgment which is based not just on what Mr. Justice Bright assessed the merits or the weaknesses of the defence to be, but very much based on the conduct of Xinbo at the time. So even if the judge below had this in mind when he made...
You mean Xinbo?
Sorry?
Did you mean Xinbo?
Oh, apologies, yes.
I mean, that's quite a... I mean, as I understand what you're saying is, whatever had passed in the proceedings previously involving dynamic, Xinbo had been given permission to be, or Xinbo had been joined at a time at which the only live issue on the pleadings to which it could respond was to say that the transaction was the underlying transaction was not a transaction under value, it was perfectly legitimate, and the shares are Xinbo's, free and clear. And you'd been given permission, you'd been given permission to be joined, you'd been joined without condition to be able to argue that point. And at that stage, there was no other reason for joining, there was no other claim against you. You say that the only thing that changed was that you didn't file your defence for a month within the time that you'd been given.
Yes.
And the sins of dynamic, such as they were, should not have been without more visited upon. And it was not an appropriate response to your default to make you, in effect, procure the transfer of shares which you claim are yours to the claimant, sorry, to ETS. And or that it was a disproportionate response to your default.
Yes.
And really that's it.
That is it. Yes.
You know, so whether it's proper or disproportionate, I mean, those two points, your third and fifth points, you added your fifth point, and I submit the fifth understood to be part of your third. But
Yes.
you say really that's the question, and the judge didn't really grapple with that. He simply treated you as the same as dynamic, because he didn't like the corporate reality or all this sort of stuff he put in paragraph 2, and you say actually just wasn't analysing the position properly at all.
Yes.
I mean that's as I understand it. I mean, have I misunderstood the basic proposition?
No,
That's helpful. That clarifies what you were intending to cover by proper purpose.
yes. I think that really encapsulates our argument on.
Because what you say is, in effect, what he was doing was granting summary judgment against your client, or akin to summary judgment against your client, when on the only point that you'd been joined to come and argue about whether the shares were yours or were transferred pursuant to an unlawful illegitimate transaction.
Well, that is.
And for a failure to file your defence for a month, that was not an appropriate or disproportionate reason to grant that order.
Yes, exactly. But I mean, that is our argument on Paul.
Incidentally, is there a transcript that's being taken? Are these microphones taking a transcript?
Well,
No.
the factual answer to this is that they are, in the sense that one can be bespoken in the usual way from what used to be called the mechanical recording department. But I don't think you've arranged for a special transcript, have you?
No.
Fine.
No, we haven't.
Friends are not caught.
I see what you mean.
Sorry, I just wondered. Sorry, because it may be left over from another case in which there's been a transcript.
There was yesterday a transcript, and I can see why my lord thought that. My lady and I were in this talk, but he wasn't. The laptops down there say Opus on them, and that's why these are here.
Okay.
I think you would know if you'd arranged for a transcript. In
it's
theory,
not
we
ours.
would know too. But
The only reason I'm going to say is because if we're not having a transcript of this, can you give me a moment just to write down
Yes,
something?
of course.
can we just look may not have any point on it, but I just want to remind myself of the way in which the application for conditions was formulated. You tell us where it is, I forgot, I've marked it already. It's tab 16 in the supplemental bundle.
Yes, it's paragraph 5 of Yardley 8, which is in the supplemental bundle at page 94.
Yeah, so the order is characterised at page 89 as being one which imposes conditions on the fourth defendant's ability to defend the proceedings, which looks more like Order 24 language, although I agree it's not formulated as such, sorry, Part 24 language, pursuant to CPR 3.13. But of course, if you looked at CPR 24.5, it actually refers back to CPR 1.3. So that's formally it. The draft order which is attached isn't actually attached here, but is it the same as the one that was eventually made? Perhaps someone could just
Yes,
over lunch.
we can check that point.
Maybe we've got it at.
Well, it's obviously different in some as to the substance and so on.
Maybe it's at 121. Is it? Can someone tell me?
Yes.
Tab 18.
That's the draft.
That must be the draft order attached, and then it's supported by a witness statement from Mr. Yardley. Well, I won't take up time looking at it now. I'm just looking. What's at the back of my mind, as we would have gathered from earlier observation, is to what extent this is substantively different from a summary judgment application. Although the hook on which it is hung appears to be, though it's not apparent from the application itself, the default in filing in time.
Yes.
Okay, well, as I say, I think we'll have unlikely to be finished by the shortest German, so I'll have a look at it over lunch from that point of view.
Can I also understand one other thing, and I may have misunderstood the chronology here. When Mr. Justice Knowles was making his summary judgment decision that led to the order to transfer from Dynamic, is it the case that at that time Dynamic didn't have leave to defend because it had failed to comply with the order of Mr. Justice Bright?
Yes, that's correct.
So the summary judgment that was actually obtained was obtained without there being a defence.
Yes, that's correct.
It was so. Yes, I'm afraid I haven't followed that. So was it in fact a summary judgment under Part 24, or was it a default judgment?
Under Part 24, wasn't it? It was under Part 24, Lord.
Could have been a default judgment.
It's not a summary judgment that disposes of the whole case, though, is it? It doesn't dispose of the monetary relief claims, so I don't.
It's a long time since I was never totally a master of the White Book. I'm certainly not now.
The order says in terms, Mr. Justice Robin Knowles' order says in terms, there shall be summary judgment in favour of the trustee on its claims against Dynamic for the return of the shares, but against ETS and Dynamic for return of the unpledged shares. And
that may in fact be that you can't get a default judgment except for a monetary sum. That certainly used to be the position. Yeah, okay.
Yes, I think that may be the case, my Lord.
Your point is that you were joined to be able to argue, not being bound by that summary judgment, that in fact the underlying transaction was a valid transaction, no matter how weak everybody thinks your defence might be. You were joined to be able to argue that point. And the effect of the judge's order is that because the condition is that you procure that Dynamic comply with that summary judgment, the shares will go back on an unrestricted basis.
Well,
there's no way back for you if you comply with that, as I would understand it. That's your point. That was your prejudgment point.
yeah, I mean, there are two points. There's one is that the nature of the order made is in fact not just a condition. It is in fact a summary judgment, meaning that your leave to defend, at least as regards that part of the claim, is meaningless. That's just park that point, to which there may or may not be an answer, but park that point for the moment. Are you saying that it would have been inconsistent with the joinder, which was by consent, wasn't it?
Yes.
It would have been inconsistent with the consent for Xinbo to be joined in order to run the defence, which everyone understood was the purpose of it being joined, for an application then to have been made for summary judgment. I would have thought it wouldn't have been. It wouldn't be implicit in the consent that that GLAS was acknowledging in a binding way that you had an arguable defence.
Yes, well, we would say that clearly that would be an argument.
Can we just see the terms of the consent order? Is it behind tab 13?
I think, Lord, just...
I understood this was the point you were making in paragraphs 42 to 44 of your skeleton, just out of interest. You were stressing that at the time you were joined, everybody knew that there had been breach of the orders, and indeed there'd been this summary judgment. And I think you were pointing out that GLAS consented to your unconditional joinder and filing of a defence, and the only thing that changed was the fact you didn't file for a month. I mean, I think I put it to you earlier, that's as I understood your case to be.
Yes.
Yes, sorry, it's not tab 14, it's tab 15, isn't it? Was that a consent order from the start, or was it an opposed application which turned into a consent?
I don't think it was ever opposed, my lord.
We can see from the recitals that Dynamic applied to join you. I'm sorry, my lord, my lady are probably more on top of this than I am, but GLAS served evidence in response. What was its position in Yardley 6?
I think Mr. Barden will tell us that it reserved its position.
It reserved.
In Yardley 6.
It was, so I didn't hear what.
Reserved its position.
Reserved its position, right.
Conditions.
Then Dynamic, that's right, Dynamic made certain concessions as its further evidence. It's then listed to be heard. And then the parties all come together. Yes, I see. Well, in any event, your position is, as my lord points out, who's already explicit or implicit in your certain argument, that that was that the eventual consent by GLAS to your joinder was inconsistent with any subsequent application for summary judgment.
Yes.
There wasn't one in the event because you didn't, but instead an application, at least for conditions to be imposed on your leave to defend, was made in the light of your failure to file in time.
Yes.
Okay, thank you.
I'm now going to move on to my argument about lex specialis, which is the last point about the procurement condition, which is dealt with in paragraph 47 of our skeleton. And we rely in paragraph 47 on Deutsche Bank and Unitech. And it's paragraph 35, Lord Justice Lombard, paragraph 80. He sets out the principle, which is at AB Authorities Bundle 201. And we also set out in the skeleton actually at paragraph 35, where the relevant passage is set out. So where there is a specific rule in the CPR which deals with this type of application, CPR Part 3.13 cannot be relied upon as a means of circumventing the requirement of that specific rule. This is a form of lex specialis reasoning. As a matter of principle, the requirements of a rule specifically crafted to deal with a particular type of application cannot be bypassed by recourse to the wide case management powers of CPR 3, which have not been so crafted. And in Huscroft, this court held that 3.13 did not allow the party to circumvent the requirements in Part 25.12 and 13 governing security for calls. And our point is that that applies equally to this case, where we say that the procurement condition effectively amounts to a mandatory injunction compelling Xinbo to procure the dynamic transfer the shares.
Sorry, can I just be clear about this? I'd certainly misunderstood your lex specialis point until now. Is it different from the point you've already made in a different context, that actually you're being granted under the guise of a condition, or not, you're being subjected under the grounds to, in fact, the substantive relief required in part of the case, final judgment on part of the case? That's not a lex specialis point, but that is obviously a freestanding point.
It is a freestanding. Well, they're related, my lord, if I can put it that way.
The lex specialis point is about using the general powers under the rules to circumvent a particular regime under the rules, yes. And depriving the other party of procedural protections that would apply there.
Yes.
And we see it in connection with security for costs and so forth, but it's not really what's happening here, is it? I'm trying to see what the point really is. Is it really a lex specialis point at all?
Well, clearly there is the point, the prior point, which is that effectively this is a bit like granting summary judgment against Xinbo,
yes.
Because you're taking away the very asset which it seeks to contest in the trial. There is I suppose that the same point can be made about that that's effectively an application for summary judgment, but without going through the normal summary judgment hoops.
Well, just pause there. There aren't any relevant summary judgment. Substantively, you haven't lost any advantage that you might have had if this had been pursued under Part 24. Would you? Have you?
Well, I think what I would say is this: that clearly the way that obviously there was some reliance on the weakness of the defence, but had it been a summary judgment application per se, then the judge would have had to have focused much more heavily on the merits of the case rather than simply referring to what had been said previously by Mr. Justice Bright, for example. So I think the way that the application would have been dealt with would be different, even if there are no particular formal steps or substantive points to be dealt with as a matter of summary judgment. So
it's quite common. I don't know if it's a helpful analogy. It's quite common in deciding whether to give permission to amend to effectively decide the merits of the point which is being sought to be raised by amendment as a reason for refusing permission to amend, irrespective of any points that might be made about the procedural history.
Yeah.
Nobody says, "Oh well, you're that ought to be that's abusing the power to refuse to amend because you should be instead framing this as a summary judgment application." I'm just wondering whether you're being far too technical about this.
Well, maybe I am, but I mean, I'm not saying that you can't take into account the merits of the defence in considering a condition, but in the circumstances of this case, where we're only in this case to defend and to contest the nature of the transfer and to assert our rights in the shares, the condition effectively deals with our rights and puts an end to any meaningful participation of Xinbo in these proceedings. So in those circumstances, the substance of the conditions application is actually a summary judgment application, in which case it's not enough. You're quite right to say that you can deal with merits as an adjunct to another application. That's quite correct. But we would say that where in substance this is actually a summary judgment application which is going to end our meaningful participation, it's got to be much more front and centre in terms of the reasoning of the judge and his analysis of the case, and he simply doesn't go through that process at all. I mean, he can't, we would say it's not enough simply to refer to the judgment of Mr. Justice Bright. He would have to reconsider those issues and the arguments and to consider them afresh if he were to do that.
I mean, as I understand it, I mean, in addition to the point you made, the judge doesn't really deal with it as, in effect, it was a summary judgment application because it was effectively ordering you to procure compliance with a summary judgment against your trustee, if this is right. I mean, well, not only does the judge not deal with it as such, but he doesn't explain, it just doesn't approach it on that basis at all.
No, that's just not the way it's framed, and it's not the way he considers the application.
But that was the substance. In effect, you say that's the substance. You're being deprived of the opportunity to do that which you had been given permission to do when you were joined.
Yes.
And you object to that being the consequence of having failed to file the defence for a month.
Exactly, and renders the trial completely
on that point.
On that point, yes.
Sorry, I've slightly derailed you on the lex specialis point, but is there more you want to say about it?
My Lord, simply to say that obviously there's the much broader point about summary judgment. There's the slightly narrower point about if this were to be treated as a mandatory injunction, then it would also be a circumvention of those rules. And
what would the relevant rules be that were circumvented?
Well, we would say that the test would be slightly different. It'd have to be, for example, the judge himself adverted to this during the hearing, and we've already looked to some extent on that, but just to come back to it, in the supplemental bundle at page 179, the judge himself discusses whether or not an injunction would be granted. And it's page 179 and it's line 50. Is it page, sorry, it's page 15, lines 3 to 12. Where it says if you think of it.
Oh, is the passage we've looked at already?
Yes, exactly. He says you wouldn't get an injunction that compels in positive terms D4 to procure the other entities to do that, because in the state of the evidence it's not clear whether it can or cannot.
Well, that's not really a lex specialis point. I mean, that's it's not because of some peculiarity of the procedures available for getting a mandatory injunction. It's simply a point of substance. You shouldn't order someone to do something which they can't do, or which there's reason to believe they may not be able to do.
Well, I suppose you just have to set out the basis of the injunction against Xinbo as a separate party, which would have to be done to protect against the harm which Xinbo could reasonably be required to deal with by way of an injunction. So, I mean, I suppose you would still have to formulate an injunction against Xinbo, which would be a much more focused exercise than applying under 3.1. It's not been framed in that way, if I can put it that way. So maybe I'm putting it in a technical way when it's not. But,
anyway, so that's the next bit, and the proportionality point, which is your fifth point, while we were looking at the procurement condition, you've really, at my lord's invitation, bundled up into your purpose point.
yes, I mean, I think we've, to some considerable degree, already covered that in distinguishing between the conduct of Xinbo and dynamic. And obviously, I referred earlier to some of the features of Mr. Justice Bright's order. I mean, for your note, in respect of that, in the supplemental bundle, page 45 to 46, paragraph 70 deals with the specific failure of dynamic, for example, to deal with deals with the specific failure of dynamic to deal with the freezing orders which were in place. Paragraph 77 is of his judgment at page 46. Deals with dynamics, what was described as culpable delay, and paragraph 84 deals with significant disruption, that's at page 47, and paragraph 127, which is at page 56, deals with, I quote, the fact that Ms. Q and Dynamic both chose not to participate in the proceedings for a very significant period. So it just comes back
What's the point you're making? He does indeed make all those criticisms, but what are you saying?
Well, what I'm saying is that in terms of procedural default, Dynamic's position was very different to Xinbo's position.
Yes, I see.
So Xinbo had failed to file a defence within a matter of weeks, having been given permission to defend.
Yeah, but the real point is whether it was legitimate for the judge, as he clearly did, to bundle in the earlier defaults of Dynamic in deciding whether to impose a condition on Xinbo. That in turn depends on whether he was really concerned only with Xinbo's comparatively trivial failure to meet time limit, or with the broader question of the merits of the Xinbo defence.
Yes, and we say in circumstances where the only thing that had really changed was the fact that Xinbo had failed to file its defence on time, but had been given permission.
Yeah, well, it all plugs into the points you've made already.
It plugs into the points I've already made, so I don't want to go back into those.
So that's your case, if I'm not rushing you too much, on the procurement condition, and of course, much of your submissions, but not all, depend on the payment condition. Apply here equally, but not all.
Yes, no, that's correct, my lord. A lot of them do shade into each other, and of course we've already touched on the fact that there was no pleaded case in damages against Xinbo at the time that this matter came before the court below, and of course the first strand of our argument on the financial condition is that there was simply no basis for ordering a financial condition against Xinbo in circumstances where there was no pleaded relief against Xinbo in damages, and indeed that Xinbo had been joined without condition to deal with the matter of the transfer of the shares and to go on to assert its rights in respect of the ownership of the shares. And of course, we say that whereas Mr. Justice Bright imposed a condition in his 2nd of February of 2024 order on miscue and dynamic, that condition was imposed based on an assessment, an estimate of what the likely damages would be, a conservative estimate, against those parties. And of course, that just wasn't an exercise which the judge could undertake in these circumstances where there was no pleaded claim as against Xinbo.
But am I not right in thinking a claim had been articulated in submissions?
Not a claim in damages, my lord, no. So this point was raised before the judge, and it wasn't intimated on that occasion that a claim in damages was going to be added.
Precisely.
So there was no claim and no intimation of a claim that I'm aware of. That I recall.
So effectively, the payment in was a payment in respect of a liability of dynamic.
Exactly. Exactly. And the 2 points that were made on the financial condition by GLAS were that we were stepping into the shoes of dynamic. That's in Mr. Yardley's 9th statement, paragraph 30, and for your note, that's in page 170 of the now agreed but previously unagreed bundle. And the second point.
Sorry, can we just look at that?
Yes, yes.
So this is Yardley 9. Yes, I see. Which paragraph did you say?
It's paragraph 30. It should be on page 170, is that right? Yeah.
Yes.
And there in the paragraphs below, say 32, we've got the ability to pay the 18 billion. Control of dynamic is 37.
Yeah, thank you. Sorry, do go on if you're waiting for me.
Oh, I'm sorry. Yes. So, so those are the arguments which GLAS put forward in support of it.
The arguments in what, 30 to 37?
Yes, it goes on for quite a while, but these are the arguments that were put forward. All going to the argument that Xinbo was effectively stepping into Dynamic's shoes as a party.
I mean, there was a claim against Dynamic at the time. So I mean, we haven't actually looked at the pleading case at the time before the judge. But I think there was a claim against Dynamic, wasn't there? Monetary.
Yes, so the monetary claim is left over after the transfer of the shares. So the claims that that remained before the judge were the monetary claims against Dynamic and Ms. Q.
But that is a claim for what?
Conspiracy. Section. Is there a claim about financial?
43 claim.
43, which is to make up the shortfall if the shares don't realise sufficient monies. I'm doing some considerable violence to my friend's case at the moment. I'm sure he'll be corrected. But the basic gist of the claim is that these financial claims will mop up any shortfall in the value of the security.
Right. The document we've got in the bundle, the core bundle at tab 7, which is the re-amended particulars of claim.
Yes.
I'm just trying to understand which bits of that were in front of the judge when he made his order.
Yes, everything except the yellow, as I understand it. Yeah. So it's just the yellow bits which were not.
Remind me where the yellow bit is. It's in para 40.
Prayer and also yes. Is that it? Yes, paragraph 40. And also 33C.3.3.
Yep.
A little bit 33C.3 as well.
Yes, don't worry, I
wait for it.
can find it if necessary, yeah. Whether I can read it once I've found it is another matter. But
So it would be right though that although no relief was sought against Xinbo, and you see that because the prayer doesn't, anything relating to Xinbo is in yellow in the prayer. So that wasn't in front of the judge. So there was no actual monetary claim against Xinbo in the prayer at the time the judge gave his judgment. There was at least an allegation that Xinbo was party to the conspiracy, because that is at paragraph 41.
Yes.
Right.
Yes, there was that allegation, and that's the slight curiosity about this case, if you like, because we actually from the beginning of all the versions of particulars of claim made various allegations against Xinbo. Some of those allegations have been fortified slightly and expanded upon as time goes on.
But if you go back to the front page, Xinbo being added as a party is in yellow. So the version in front of the judge didn't have Xinbo as a party. Quite hard to do a prayer for relief against someone who is not a party.
But
Should have been. It should have.
actually, I'm not sure that's right, because if you
Not
look
quite
at
sure why that is, but we'll need to get to the bottom of that. But
well, to pick out my lady's point,
Do a defence before we did have to.
But
the particular
surely-
thing you filed after that didn't have any.
the
relief,
yellow,
did they?
the
Sorry.
yellow seems to have, at the top of page 60, the yellow seems to say, in particulars, whiteboard of Mr. Justice Bright, dated the 7th of February 2025,
it-
which is post
yes, it is. I think it's.
judge's order.
Is it not fairly straightforward? There wasn't. Although Xinbo was a party by the time,
Yes.
there and had been joined, as it were, for its own reasons, which didn't involve. Been joined for its own reasons. There was not at that point a pleaded case against it, which is what you've been saying. And therefore, the pleading that was in front of him wouldn't have named it as a party, because at the time that pleading was drafted, it wasn't a party.
No, I think
Well, we can see it wasn't named as a party, and you wouldn't expect it to be.
My understanding is that the previous version was produced before Xinbo was joined.
Yes.
Yes, if it helps, the joinder order is at page tab 15 of the supplemental bundle, which is page 87 and 88.
Yes.
And you will see in the numbered paragraphs of that order.
Sorry, which order?
This is the joinder order of the 5th of September.
This is the consent order by Justice Andrew Baker.
Exactly. So what happened was Xinbo was joined, that's paragraph 1.
Yeah.
The trustee, that's my client, was required to serve the re-amended particulars of claim. So that's the one with the pink or magenta or whatever you want to call it, amendments on Xinbo, i.e. the existing version.
Yes.
And there was then provision for Xinbo to file a defence to that.
Yes.
So Xinbo, in effect, was supposed to produce a defence which engaged with the pre-existing pleading, which, as my lord noted, identified that Xinbo was alleged to be one of the conspirators. Yes. But at that point, we had not got to the stage of adding the monetary claim.
In a way, it's a little bit anomalous, though, to expect it to plead to a particular claim which made no allegation against it.
Well, it did make allegations against it because it's
all right, but they made no claim for relief against it.
It didn't make the claim for monetary relief. I agree, my lord. The submission I will make, if I'm going to sit down now, is that it was obviously very clear that that claim was coming.
But you're, sorry, just to make sure I've understood, that you say the reference to amended particulars of claim in paragraph 3 of that order is not to a version with further amendments
Yeah.
that were subsequently added.
Yeah.
Exactly.
The-
And it may be thought that it might have been better that the parties should have agreed that we make those further amendments and then they do their defence, but that wasn't the order in which it in fact was agreed.
Hang on 1 second, yes. Because the one we've got is re.
Indeed.
Yes.
And so the yellow is additional.
Yeah, okay, hang on 1 second. But none of this was ever argued out because it was a consent order.
Yes.
That's to say the order of pleadings. Just remind me, what was the basis on which Xinbo asked to be joined? What was its purpose in asking to be joined? It'll be stated somewhere in the affidavit of whoever, but in support, the witness statement in support of the joinder application, presumably.
Well, Xinbo's purpose was to assert, ultimately, to assert and to assert its interest in the shares and to protect its rights in the shares. That was the purpose of Xinbo's
Did it
participation.
include a counterclaim? Or
Yes, the
cross-claim?
counterclaim is for a declaration in respect of its interest in the shares.
And an order that the shares be transferred to it. Yeah.
Yes, I'm sorry, I hadn't looked at that, but that's what I would see if I did.
Yes,
Yes,
that was
okay.
it. So that was the purpose of Xinbo's participation, to
Yes.
assert and to ultimately receive those shares.
And there is that all makes perfectly good sense, and I understand it. But do we have there was presumably a witness statement in support of? Well, I was wrong to say Xinbo's application because it was Dynamics application,
It
but
was Dynamics.
some might say an understandable slip. But Dynamics application, have we got the witness statement in support of that? The application was made on the 22nd of March.
Just is it in here? Can we produce it? We can.
There must have been one, mustn't there?
We can find it, my lord, and we can.
It's not in the unagreed bundle
I
even.
don't think it is.
Now agreed
I
bundle.
also don't think it is. We'll check. But
Yeah.
don't-
We can.
I think it would be useful to see that because everything you say makes sense, but that is where there will be a formal statement by Dynamics saying we want Xinbo to be joined.
Yes.
It'd be a little bit odd if it said we want Xinbo to be joined in order that Xinbo can make a cross claim, but
I don't think it says that. I think it
Brilliant.
says in general terms that we want Xinbo to be joined because Xinbo's
because it's a necessary and proper party, or whatever the phrase now
exactly.
is.
Zimbo's the real party to these proceedings. Zimbo's the one with the beneficial interest in the shares.
And Xinbo never and okay, have we got Xinbo's response? The recital at 87 says, upon Dynamic serving evidence on behalf of Xinbo, seems slightly odd phraseology, but still, Zhang for which Xinbo confirmed. So have we got the witness statement of Mr. Zhang or Ms. Zhang of the 3rd of July 2024?
I don't think that we do, my lord, but again, we can certainly get that for the courts.
It is probably, once one sees it, it'll all fall away. But I just feel we have a more complete picture of how
Yes.
this was put together without
Absolutely.
if we had those materials.
We'll get that for the
Yeah.
court. We'll circulate it. Certainly.
Or if that can be done to our clerks, if possible, over lunch.
Yes,
Um,
certainly. I'm grateful. Well, just picking up on something my friend said about it being obvious at the hearing. That I'm grateful for his refresher, as it were, on the precise sequence of events that led to that particular document being before the court. But as Your Lordship has said, at the time, there was nothing in the particulars which obviously intimated a claim against Xinbo. And we were pleading to a defence in a rather odd fashion, as you say. But what's also important to note here is that this was a point which was argued out in front of the judge. We laid heavy emphasis on the fact
Yes.
that there was no pleaded case.
And he does, to be fair, though not, it might be said at great length, refer to it. He acknowledges that that is one of your points.
He does. But what's critical, of course, is that what was not said at that hearing is that GLAS are obviously going to plead out a case in damages when they get the particulars back and are going to amend them. But that's not what was said. So the judge didn't have it in mind at that hearing that, oh well, there's this rather strange procedural dance where the pleadings have gone in a slightly strange order. He didn't have it in mind that that was just some foible of the directions that had been given. He wasn't told that there was going to be a case pleaded against Xinbo for a monetary sum. That wasn't what was said. That wasn't the argument that was put. So the judge did not have that in mind. So we say it can't be assumed that that's what was going to happen, because that's not what he was told.
But of course, we now know there is such a claim. Suppose the position is that may not be the route we take, but suppose the position were that we were to hold that the judgment was wrong for inadequate reasons, but were proposing to remake the decision ourselves. It would be presumably appropriate for us to do so in the light of the pleading as it now stands.
So it'd be appropriate for this court to substitute a decision, did you say, my lord?
Yes.
If we were deciding whether to uphold the judge's decision,
Yes.
but for our own reasons,
Yes.
we would surely have to proceed on the basis of the material before us.
Yes, if you were to consider what order could be substituted.
Yes.
Yes, absolutely.
Yeah.
But we would say in those circumstances that the court would have to reflect on the fact that it is only fairly recently, of course, that a case has been pleaded for a monetary sum against Xinbo. That was done in February of this year. So insofar as the court reconsiders the exercise of the discretion, it has to take into account all matters, including the nature of any default in not filing the defence, which at the time didn't have any financial relief in it, and nor was any indicated by GLAS at that time. So I think, yes, it is something that obviously could be taken into account by this tribunal, but it would have to exercise that discretion with in mind the fact that the events as they've unfolded are slightly unusual, because that financial claim has only come in fairly recently, and that puts a slightly different slant, we would say, on the exercise of that discretion.
Yes, thank you. Right, now just so we, this is already your first point under the heading of the payment condition, that there's no pleaded claim against Xinbo. Yes,
it is, and I mean, there's a number of kind of quite superficial points to be made, of course, that obviously in terms of the numbers, it's difficult to understand why we've got to the
sorry, I just didn't hear what you said. The superficial points, namely... Superficial
points about the number which was ordered, which is 10 million, which is obviously more than 9 and less than 18, but of course doesn't really follow any logical analysis, if you like. It's not the amount that Dynamic was ordered to pay, which was...
Well, you described that as a superficial point. Are you saying that was an illegitimate approach, or is it what you might call a debating point?
Well,
I just don't know what you mean by saying it's a superficial point.
Well, we say it was an illegitimate approach because the sum which was ordered was not based on any logical analysis of the position. We say that primarily, of course, because there was no financial sum sought against Xinbo. But even if one were to conflate Xinbo and Dynamic, clearly Dynamic was ordered to pay 9 million. So we struggle with the arithmetic of this. However one analyses it, but we say that the numbers that were ordered clearly don't make any sense as they stand, and that there's nothing in the analysis of the judge which would allow one to understand why he ordered that particular figure against Xinbo. But of course, our more fundamental point, of course, is that given that there was no financial relief sought against Xinbo, there ought not to have been an order that it posts security in respect of a claim against Dynamic, which is the phraseology that was used by the judge. And of course, we've already gone over what we say is the distinct legal personality point. We say we ought not to be made to post security for Dynamic, and that the judge ought to have taken into account our separate personality. And insofar as the arguments of GLAS are concerned with this, we say that we weren't simply stepping into the shoes of Dynamic, but we were given permission to defend, and we sought to protect and to enforce our rights in respect of the shares, and that's what we seek to do as a party. Insofar as the subversion argument is concerned, I think you have my point on that already, that if it was subversion before the judge below, then that really is very inconsistent with the consent that was granted by GLAS in the first place, when we were given unconditional permission to file a defence. Insofar as
and just so I understand your point, I mean, if you look at the judgment, paragraphs 3 and 4 of the judgment, the judge's reason for requiring Xinbo to make a payment, the payment of 10 million euros, was to protect the dignity of the court process in circumstances where there is evidence on the face of the record here that its dignity is not being respected. That's the reason the judge gives.
yes,
As I read his judgment. I mean, he says it's in the interest of justice, which probably most judges would think that that's what their judgments are supposed to do, but it's specifically the first sentence, paragraph 4. So it's not clear, as I understand it, what he's doing. Is he saying that Xinbo should make good on the default of Dynamic and Miss sorry, I can't remember her name, Mrs.
Q. Yes.
Or is it that he's making the order against Xinbo in its own right for its own conduct? And the reason I try and understand it is because when he says he's going to order 10 million, and not just because it's not 18 and it's not 9, the 18 and the 9 come from the order of Mr. Justice Bright,
Yes.
as I would understand it, which is orders against Dynamic and Ms. Yu for 9 each, so 18 or 9. What do you say, or what do you understand the judge to be doing here? Is he making Xinbo, as it were, make good the default of either of those two individuals? Because of the connection between the parties, or is he picking a number in addition for Xinbo itself?
Well, the simple truth is that we don't actually know what the judge was doing. There are some parts of the judgment which suggest that he was in effect visiting the sins of dynamic upon Xinbo, and he places quite a lot of emphasis on the judgment of Mr. Justice Bright in various places. He refers to it during the hearing in a number of places. He also refers to it in paragraph 1, but of course we would make the point about that. Of course, Xinbo and Dynamic were in very different positions when they came before this judge, and respectively, Mr. Justice Bright when Dynamic came before that
So
judge.
can we just be clear about this? You say in very different positions. The only point you've made about the difference of position is that Dynamic has behaved abusively, if I can use that as a shorthand, and you say Xinbo hasn't. Is that what you mean by they're in very different positions?
Yes, I mean, the Dynamic had a very long delay.
Well, okay, no, you
Yes,
don't have
so-
to make the point again. I just want to make clear that is the point you make. Yeah, right.
That is the point. That is the point.
Yes, I see.
And that sort of chimes with the judge's comment about protecting the dignity of the court in circumstances where there's evidence on the face of the record here that dignity is not being respected. If all he was looking at there was a failure of a month to file a defence, it's a little difficult to understand why he would speak in those terms. It's understandable if he speaks in those terms because of the conduct of, as he would perceive it, the conduct of Dynamic or Miss Dew. And so I sort of understood that in truth what he was doing here was actually, as it were, visiting the sins of Dynamic and Miss Dew in not protecting the dignity of the court on Xinbo, which sort of chimes with the first sentence, paragraph 5. And my sort of understanding here is that he was not treating this as anything to do with a claim against Xinbo itself, because he also points out that there's no claim completely against it at the time. But in effect, he was saying that because of the breaches of, or the failure to comply with the previous orders by Xinbo and Miss Yu, he was going to require, sorry, the previous abuses by Dynamic and Miss Yu, he was going to make Xinbo effectively make a payment of a similar amount that they had been ordered to pay but had failed to, as a condition of running its own defence.
Yes, I think that's the most likely interpretation of the defence. Because as you say, my lord, the reference to the dignity of the court, it would seem far-fetched to make that kind of comment about a very minor delay, which Xinbo was responsible for. It seems far more likely that that attaches to the long history of Dynamic and Miss Q. So we rather assumed that what he meant by that was a reference to their conduct and not the conduct of Xinbo. But of course our point is that it's just the wrong approach.
Well, is it the wrong approach if he is right in treating all the conduct of Dynamic and Zhu and Ms. Zhu in the earlier proceedings as the responsibility of Xinbo, which is he clearly thought that this division into different individuals and corporations was surreal, is his phrase. What is that? Of course, we must respect the separate corporate identities, but where somebody who is not at the time a party, or they've now become a party, is found to be running the show for all the parties, is it obviously wrong in principle for him to do what he did?
Well, I'd make 2 points for that. First of all, I don't think the case against us was that we are influencing or controlling Miss Q in any way. That's never been the way the case has been put against us. The allegation is simply in respect of Xinbo and Dynamic as opposed to Miss Q. Miss Q is an independent party with different solicitors and has always been separately represented. So I think we can carve off Miss Q, and that takes 9 million of the conditions off, if you like, which is one of the arguments about arithmetic and why it's such a confusing order. The second point is that I think that clearly he could have made a finding in that respect that he was entitled to treat Xinbo as some kind of controlling party and that the Xinbo and Dynamic could be elided in that way. But that's not the finding that he made. That's not although he expressed skepticism about the separate personality of Xinbo.
Well, okay, but I come back to the question I make each time. Suppose he didn't make such a finding. Should we, on the basis of the judgment effectively was Justice Bright?
No, I say you shouldn't. I say you shouldn't make that finding. And you shouldn't make that finding because, as we say, Xinbo has distinct legal corporate personality. It has its own interests in these proceedings, namely its beneficial interest in the shares, and it sought from its jointer to pursue those interests and to protect them.
As I understand it, you say this was akin to the judge piercing the corporate veil. I know that's an expression which the Supreme Court has not been entirely thrilled about. You say what the judge didn't do was do any sort of proper analysis to support the proposition that there was some sort of piercing of the corporate veil to be done here, such that the behaviour of Dynamic should be attributed to Xinbo. And at the very least he should have done that and didn't. Just putting that aside for 1 second, I mean, one of the conventional exceptions to the sort of piercing the corporate veil analysis is an agency relationship. I mean, here we know it's your case and Dynamic's case that the shares are held by Dynamic for Xinbo. Would it have been appropriate for the judge to say, well, because of that nomineeship relationship, I should order Xinbo to make good the default of its nominee in paying an amount of money?
Well, I would say that would not have been a justifiable order to make. Clearly there is the exception of agency, but the nomineeship here simply relates to the shares. It's not an agency as such, and we would say that it wouldn't be the same type of exception to the piercing the veil argument that could be relied on in this case. So we understand that the nomineeship is a subject of great interest for this court, but we would say it wouldn't be sufficient grounds for him simply to point to the nomineeship and to pierce the veil in that way. So we would have objected to that.
And is that because, in part, I mean, what we're talking about here is a payment as a condition of, in effect, defending a conspiracy claim, or something which is a different type of, which doesn't automatically flow from a nomineeship in terms of the shares. Claiming conspiracy looks very differently at the conduct.
Yes.
Each conspirator.
Exactly. I mean, each one is involved in a slightly different way, so it's quite a different.
And you say the judge didn't go through any of this.
No.
But picking up my lord's point, if we were to think that we needed to do it, that's the sort of analysis you'd accept should have been done.
Yes.
I mean, you'd say the result would be no condition, but you don't dispute that as a matter of principle, if a judge went through that sort of analysis, they might, depending upon the result they reached, make an order for a condition conditional payment by the new party.
Yes, I accept that if that process of analysis were carried out and resulted in the conclusion that is hypothesised,
Sorry, and resulted in a conclusion that.
it resulted in the conclusion that one could pierce the veil in the way that's being suggested.
Sorry,
If you've carried out that analysis and the conclusion was that you could pierce the veil in respect of Xinbo.
well, I wish you wouldn't use the phrase "pierce the veil."
Well, either
My lord's formulation was better. The could, for the purpose of a condition, attribute to Xinbo the conduct of effectively dynamic. But if you're saying that if you could make that properly make that conclusion, then it would be appropriate in principle. There would be no objection in principle to the imposition of a condition.
Yeah, I think there are certainly circumstances where a condition could be imposed following that type of exercise, yes.
Yeah.
And I obviously wouldn't accept it in this case, but yes, if that were the analysis.
And not in this case because
Well, not in this case because we say that all we have here is a nomineeship, and we say that that wouldn't be the same type of argument that would give rise to an exception to the piercing the veil
precisely.
concept. And also in terms of the conspiracy claims, they're all very, very different in terms of each party. And Xinbo's in a different party position to dynamic and so on. So, you know, they're in quite different positions. So we need to obviously defend that. And what's being suggested is that we have to meet this condition in order to defend that quite different claim. So we would say it wouldn't be appropriate in this case.
and you say the reading of the judgment, the best reading of the judgment is that the judge was not ordering 10 million as a condition of Xinbo defending claim against it, because no such claim had been pleaded or properly intimated, other than that they'd been said to be a conspirator. And so you put that to one side and you say, on what basis was Xinbo ordered to make good the deficiency in conduct of Miss Zhu or dynamic? And you put Miss Zhu to one side, which the judge appears to have done as well, because if the judge had been including Miss Zhu, he would have been focusing on a number around about 18, presumably not 10. And so you're left with the proposition that what he was doing here was visiting upon Xinbo the prior misconduct of dynamic and ordering Xinbo to make good dynamic's failure to pay 9 into court by ordering Xinbo to pay 10.
Yes.
And you say that if that's what he was doing, there's no logic or good reason behind it. That's my understanding of your position. I'm not suggesting it's right. I'm just trying to make sure I have in my own mind.
No,
clear
that's our that is our position. And of course, we say that if you were, yes. So if that's what he was doing, it was wrong. And clearly, if it were a response to Xinbo's particular default, which seems unlikely, then it's clearly completely inappropriate and disproportionate. So that's our.
Now, I see the time. How much more have you got to say about the issues peculiar to the payment condition? There may not actually be many more, I think.
There's not much more to go, my lord. I just have to review my.
If you tell me it's going to be another minute or two, we'll go on over lunch. It might be neater. If it's going to be more substantial, we'll
Well, I don't think there's actually that much more to go.
No,
I could
nor do
probably
I.
finish if that's.
Yes. Okay.
So well, I think I've dealt with most of our certainly our point about the so the basis of the order and the financial condition. I think I've also dealt in this exchange with what we say about proportionality and the purpose of the order. So I think you've probably got my submissions on that already. We have some further very general points that we raise in our skeleton in paragraph 62 regarding caution and also shading back into identifying purpose and identifying the purpose of the condition, which really is actually just a subset of the purpose argument itself, which is dealt with in paragraph 68 of the scale. I don't actually think that really adds very much to what we've already said.
No, we've dealt with specifics,
with that
which is
already.
really what matters.
So I think, subject to anything I'm told, that probably is our submissions. So please.
If I may say, I congratulate you on the elegance of your timing then, Mr. Falk. Very well, we'll rise and I hope, Mr. Barden, we won't have to go all afternoon, but we what I said earlier applies. I think we will have to go in. I'm stating the obvious. 2 o'clock.
Talk to rise in table.